Okay, I want to welcome everyone to the November 18th meeting of the Contractors Licensing Board. And I guess, Kathy, you going to call the roll this morning?
Lee Carter here.
Keith Whittington, Johnson City.
Mark Brudd, Knoxville.
Bill Dement, Jackson, Tennessee.
Andy Allen, Kingsport, Tennessee.
Randy Chase, Nashville.
Gotta make sure the red light's on.
Okay, first item on the agenda this morning will be to adopt the agenda. Do I have a motion that we adopt the agenda this morning?
Make a motion, we adopt the agenda.
I'll second.
Have a second. Any discussion? All in favor say aye.
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 So moved. We also have the transcript and the meeting minutes from the September 23rd meeting. Do I have a motion that we accept the minutes from that meeting?
I move we approve the minutes from the meeting.
Second.
A motion and a second. Any further discussion? All in favor, say aye.
Aye.
Motion passes. Okay. Okay, don't
Leave
okay,
yours, leave yours on.
I just leave it.
Do ours back.
Okay. Move into the license reviews and approvals by the board. First item will be the contractor initial apps with the waived interviews. Any discussion on that item?
I'll move for approval.
Second.
Any further discussion? All in favor, say aye.
Aye.
Yeah. Next item will be contractor revisions. Any discussion on that item?
Make a motion, we approve.
Second.
A motion and a second. Any further discussion? All in favor, say aye.
Aye.
All right, next, the LLP home improvement portion. Any discussion on this?
I
I'll
make-
move for approval.
Second.
Motion and a second. Any further discussion? All in favor, say aye.
Aye.
Next will be applications with factors. No interviews. Any discussion on that item?
Mr. Dement, if I could bring up one specific application. It was in your board materials. It's a renewal application that had factors. Since that was submitted, we learned that this applicant has been convicted of a felony just last week. So I'm going to recommend that we defer the decision on this application until the next meeting, give him an opportunity to disclose all that, submit a letter of explanation, and we'll also have to go through a fresh start analysis. So given all that, I think it's best that we defer that application to next meeting. And
Okay.
if we could get a vote on that.
Okay.
Or a motion. And a
Okay.
vote.
Can we make motions on all these at once, or do we need to do them individually?
Let's do this application separately.
Then I make a motion, we accept the attorney's recommendation to table that application until the next meeting.
I second that. Any further discussion? All in favor, say aye.
Aye.
Okay. With regard to the rest of the applications with factors, any question, any discussion on that?
Mr. Chairman, I have one. It's file number 75676. It's Toll Brothers Incorporated. They made an application to add a QA with a BCAB, and on the application, they had actually listed projects that they had done with a BCB license that needed and required a BCA. Board Member Reese Smith reviewed the case, and I've reviewed it, and we're making a recommendation. And they have accepted a $25,000 consent order for contracting in a class that they weren't licensed in. So that they have accepted that, and I make that recommendation.
Okay. We have that recommendation. Any discussion on that? I have a motion that we we accept that.
Motion to approve.
Second?
Second.
Have a second. Any further discussion? All in favor say aye. Aye. Okay. All right. The Fresh Start Act, pre-approvals, denials, any discussion on that item?
I may make a motion that we accept these as presented.
Have a second? Second? Any further discussion? All in favor say aye.
Aye.
Okay. Now, recurring continuing education provider reviews, this is our next item. Chris, do we need to go one by one on those? How do we do those?
Yes, recommend going one by one.
One by one, okay. First one is American Contractors Exam Services, which is a renewal. Any discussion, questions regarding that particular one?
Mr. Chairman, I recommend that we accept the renewal or approve the renewal of American Contractors Exam Service.
I just want to make a quick comment that they're renewing, but they also are, they've merged their company with another company. You know, we have rules in effect for contractors and things like that when there's a merger, new ownership. We don't have anything specific in rules for providers. Wanted to know if we want to go ahead and accept the renewal as is, or is there any type of disclosure or any type of application that we need to consider as far as, you know, merging or changing of ownership of the providers.
Will they be operating under the same name?
They're on the same name. In essence, nothing has changed how they operate. It's just the, you know, parent, I guess, a new parent company.
They've
type
just
of-
done a merger, just,
Yes.
okay.
But again, the costs, and they paid the renewal fee, you know, it's you know, $1,500 and things like that. So there's no, but they did want to disclose that as far as, you know, what
Are
they're
they
doing.
continuing education, Chris, or
I'm
are
s-
their services are for someone that wants to study, pass the exam?
I'm sorry. I am completely confusing myself here. The
That's PDH.
PDH Academy. I apologize. So this one is a straight up renewal, no issues with that, and I apologize.
No. Okay.
But we are coming up with the next one that has what I just explained. But
Okay.
it's not up for renewal, that they have disclosed that they are coming up. So I guess we can table and then do a motion for the renewal, and then we can talk about PDH Academy.
Okay.
My
Okay.
apologies.
Okay,
Still have my motion to accept the
Right.
renewal for American Contractors Exam Service.
right.
Second.
Have a second. Any further discussion? All in favor say aye. Aye. All right. PDH Academy. Any further discussion,
Yeah,
Chris?
now that we've gotten past the first one, the PDH Academy is what I just disclosed. They're not up for renewal or anything at this time. However, they have disclosed that they have you know, a new ownership. That want to know if they need to go through an ownership change application or anything like that at this time. So again, we have no rules or statutes in place for those. So whether we want to treat it like we do for contractors, you know, they require an ownership change, or just let them continue as is, and then they renew it the next time.
If we have no rules, is that something we need to look into as a board to set forth for these providers?
I don't think necessarily. I think the ownership application or ownership change with regular licenses primarily has to do with the financials, and we're not dealing with that here. So I think we could look at getting a rule in place where they at least have to disclose their ownership change as they have here. But that would be the only thing that I really see that could be beneficial in the future.
If we don't have that rule, I think we probably should, because in this day and time, there are so many mergers and acquisitions that go on. I think that we could be looking at, you know, 2 or 3 changes in a year that we wouldn't know anything about, and I'm just concerned that as a board, we wouldn't be aware of those changes if they didn't let us know, and then who knows what would be happening to the course or whatever, so.
Totally understand that. I can definitely, when we get a new package here, pretty soon, rule package, we can include that in there and present it to you guys for initial authorization. But as far as this one goes, you're entitled to make a decision on this application. And it seems like they have disclosed the ownership change. And to me, that seems that with the financials out of play, that seems like all that would potentially be required is they disclose that. We review, make sure nothing's changed as far as their procedures and that kind of stuff.
So as far as you know, they've disclosed everything, mode of operation is the same, the personnel is the same, everything is the same in that regard. Is that correct?
Yes.
Mr. Chairman, I make a motion, we accept the merger and change of PDH Academy.
Okay. Do I have a second?
Second.
Got a second? Any further discussion? All in favor say aye.
Aye.
Okay, C-Learn LLC, which is a new provider. Any discussion on that one?
Make a motion, we approve.
Second.
Got a second? Any further discussion? All in favor say aye.
Aye.
Chattanooga State new instructor. Any discussion on that one?
Make a motion, we approve.
Second.
Got a second? Further discussion? All in favor say aye.
Aye.
Motion passes.
I've got a comment. Do we ever do anything as far as a survey from people taking these courses, just to find out how they're doing?
I am not aware of a survey, and I say that they don't do those internally, but we do often from time to time get a complaint or some type of through our complaint system or an email to our Zendesk tickets and things like that. But I haven't seen any data. Not to say we can't reach out and ask for that from the providers.
I think one thing, and along that same line, I guess a survey or an evaluation, from time to time, I don't know exactly how many different providers there are out there, but it might not, it might be something to consider to have some evaluations done from time to time, just to.
Okay.
Well, let's not forget, the majority of people do it with the Home Builders Association, and there's no education required. So, the survey sounds like a great idea, but yeah, I mean, I'd say 80% of our renewals come through Home Builders Association.
Okay, we'll definitely take that and as a due out and
Okay.
look into getting some metrics back on
Okay,
on
great,
these providers.
great. Next item is new business. We're showing the July 29th, 2026 as being a hearing day after the board meeting. Is there some discussion on that?
Just want to bring to everybody's attention, this is kind of, I guess, new to me. I guess probably not, perhaps, this is a kind of a one-off, but we have a board meeting, a regular scheduled board meeting on Tuesday, the 28th, but this hearing is scheduled for the 29th, so it'll be an extra day. Just put that on as awareness, as it stands right now, just to put that on everybody's calendar. And we'll need a physical quorum for that day. I know it's, that hearing was supposed to happen.
I already know I can't be there that day.
Yeah, that hearing was actually supposed to, I think, probably happen today, but it got continued. It got continued to the 29th of July.
We've already talked about it.
Camille, you have any other comments on that, or are we good?
It's just the day after our board meeting. We don't have the time set yet, but I believe the July 2026 board meeting is set for July 28th. So the day after, we will have a trial.
Is this firm, no way it'll get settled between now and then?
It,
Can't discuss it?
yeah.
There's always a possibility, I guess, but.
It's just a placeholder, just to put in everybody's.
Placeholder.
Okay. Anything could happen between now and then. It could also get it extended to another time as well. So.
Okay. Next item on the agenda would be new rules in effect on November 18th from the January 2025
Yes.
rulemaking hearing.
So that, I'll take that one. That's today. So the rulemaking hearing that we conducted back in January with some updates to some rules become effective today. And so that allows myself as executive director to approve some applications that have routinely gone to all the board members for approval. Now I have ability to approve those. There's also some clarifying statements about the compilation report, what's required for it, gap standards, 12 months, things like that are in effect. It also changed, brought the rules and statutes in alignment for the small business classification. There was a mismatch between the rules. The rules still had 750,000 as a limit. That brought that up to 1.5. And it also talked about some things about complaint procedures and things like that. So I can go into more detail if you want. Those were kind of the highlights that take effect today. And so I instructed my staff to start sending those applications, their name changes, mode changes, monetary increases, the approval of the limited or the restricted residential license, and reinstatements can come directly to me. If there's any questions, I see anything, issues, I definitely will want to reach out to any of y'all for support and help. But again, the initials and the ad classifications and things like that will still continue to go to you all. I did a quick count of applications that we sent to the board for approval since July of 2024 of everything that we sent to you, and then I counted everything that this new rule incorporates that will come to me now to approval, and that would reduce the amount of applications that we sent to you all by about a third. And so that's kind of the metric going forward that we think that will reduce your burden by about a third. So,
Okay.
any questions on any of the rules?
Any questions for Chris?
I would just add, we had the last step in the rule package is the Government Operations Committee, and we had Randy come sit in over there with us, just having a board member present. So I don't think he didn't get to speak or didn't get acknowledged, but I wanted to acknowledge it here that he sat in with us, and that was the last step where it goes in front of the Government Operations Committee. So he got to see that process.
Good.
I think he's done that before, actually, too. So.
All right, any other questions regarding new business? We can move on to the legal report, and Ms. Sarah Lou, we defer to you.
Yes, good morning. So I have two changes that I'm going to read, and then Sierra will also read her changes. The first change is number 55 on the legal report. That's case number 20250478881. The penalty is changed to $5,000. And the second case is number 81 on the legal report. That's case number 202504391. The penalty is changed to a $24,000 civil penalty.
Good morning. I have a few changes. So number 65, case numbers 2023-003251 and 2022-051981. The recommendation or the finding is to close and flag. Number 85, 2025040781. The civil penalty will be increased to $10,000. Number 86, 2025050611. Will issue a letter of warning. Number 98, 2025053501. The civil penalty will be increased to $1,000. Number 73, 2025014941. This was represented due to the respondent's attorney requesting reconsideration by the board and to issue a written reprimand rather than a $10,000 civil penalty. The board did reject the request and is gonna uphold the $10,000 civil penalty. That attorney also requested to make some small changes to the consent order that we send out, advising that they are being assessed a civil penalty. And I'm just asking that the board allow me to work with the respondent on settling the case with the previously authorized penalty, which is a $10,000, and to negotiate the language in the consent order.
Okay.
And that's it.
Any questions for Ms. Shepherd?
I'll move for approval of legal report.
I have one change real quick, board members. Number 69, that is case number 2023-036481. That is being changed to litigation monitoring.
I'm gonna second Mark's motion, but do we need to add something for her request to, on her case?
You can either do it all together if you feel like you want to pull that one out separate and vote on that one separately, and then however you want to do it. But I think that's the change. So if you want to do the legal report as amended in whole, you can do that.
Yeah. So we have a motion to accept the legal report. Do we have a second?
Yes.
Got a second? Any further discussion? All in favor say aye.
Aye.
Aye. Motion carries. Kyle, legislative report.
Yes, I really don't have much. Chris kind of stole my thunder on the updating you on the rules being effective today. So that was really what I was going to talk about. And if you all have any questions over them, feel free to reach out to me.
Any further questions for Kyle? Do I have a motion that we accept the legal report? I mean, the legislative report.
Motion to accept.
Second.
Motion to, and second. Any further discussion? All in favor say aye.
Aye.
Okay. Board updates. Mr. Burkhart.
All right. Good morning again. Just a quick update. We are continuing to get new applications and reinstatements. We are well surpassed all those two metrics from last year already. If you look at that second table there in the middle of the page, we're in November, but we're still receiving new applications all the time. Just as anecdotally, last week we received 70 new applications over a course of a week. So it's we're no sign of slowing down. The industry is slowing down. Overall, we have over 35,000 licenses, active licenses in the state. And so, other than that, we are again we'll update our processes as we described about the new approval process. But other than that, any questions on anything that you're seeing for me?
Any questions for Chris? Okay. Sunshine Law presentation from.
Yes, we're going to get this PowerPoint up for you. This is a refresher. We have to do it every year, so I apologize if it takes 15, 20 minutes, maybe a little boring, but it's good information to be refreshed on every year. So we'll get through it. All right. Give us 1 second, and we'll get this PowerPoint going. All right, so today we'll be covering the Open Meetings Act. We'll have a brief refresher on what public records are, and we'll also cover a landmark case that you all have probably heard of before. Click next slide, Kathy. PowerPoint's titled, "You Are My Sunshine." Clever name, I didn't come up with it, but we're talking about sunshine laws. Okay, go ahead, Kathy. This is just a little disclaimer. This is just general guidance that we've crafted based on the law and stuff. But if you have any specific questions, you're always welcome to reach out to me. Go ahead, Kathy. All right, go ahead. Okay, first we'll be talking, just a brief refresher on what public records are. So just a reminder, a lot of what we do and all the records, that's, all available to the public if they submit a public records request. So that includes any documents, papers, letters, maps, books, any media, photographs, sound recordings, and then any electronic data that we have in our databases. That's all public record, and if someone submits a public records request, they can have access to that. Go ahead, Kathy. What is not a public record? So, for example, the iPads that you all use, the actual device is not public record. Now, anything within that is public record. Same if we had a state cell phone. The devices are not public record, but again, any electronic data and anything in there is public record. And now we'll get into the meat of it. This is the Open Meetings Act. We're in one right now. So we'll go over today what is the Open Meetings Act, and then we'll talk about what actually is defined as a meeting. And then we'll talk about what is required for a meeting covered by the Open Meetings Act. That really just has to do with the notice requirements that you all really don't deal with. We're the ones that publish those notices and stuff like that. And then we'll talk about briefly what happens if the board violates the Open Meetings Act. This slide right here is pretty much just the legislative intent behind the Opens Meeting Act. But as you can see there, it's public policy of the state that, or law of the state that formation of public policy and decisions is public business and shall not be conducted in secret. So you all form public policy, make decisions, promulgate rules, that's all open to the public. So that's kind of the purpose behind the Opens Meeting Act. Go ahead, Kat. So this right here, there is one exception, or can you go back, Kathy? So there's kind of one minor exception, or not really exception, but this part of the Public Meeting Act refers to the free speech clause of the Tennessee Constitution. So the way to read those two together is to understand the limitations placed on your speech and actions while serving in your capacity are first of all voluntary. You volunteered to serve, but moreover, you should understand that the legislator is not telling you what you can and cannot say, but that while serving as a board member, all that you say should be on the record and accessible to the public. Go ahead. So the goal of the Open Meeting Act is to essentially, again, public transparency. Overall, it's best to interpret the act broadly, as I would put it. If there's any question, always err on the side of caution. So the previous section said that, as I talked about, all your policies and decisions are public business. What this part of the statute here is telling you is that all your meetings are also public business, which again, we're in one right now. This is all displayed and open to the public. Go ahead. This part of the statute defines what a governing body is. So it's just some kind of public body. And so what is a public body? The Tennessee Supreme Court tells us that the legislator intended to include any board, commission, committee, agency, authority, or any other body by whatever name whose origin and authority may be traced to a state, city, or county legislative action, and whose members have authority to make decisions or recommendations on policy or administration affecting the conduct of the business of the people in the government sector. So really all you should know is that you are a governing body, but it's super broad. That goes all the way down to like a county commission or a city commission, so it covers all that too. So now we'll get into what is a meeting. What's the definition of that? Here you do have the definition of a meeting. Meeting means the convening of a governing body, of a public body, for which a quorum is required in order to make a decision or to deliberate towards a decision on any matter. So every single meeting we have is included in that definition, and you should also keep in mind that your subcommittee meetings that we have, those are also meetings. And then I don't think you've had this in a while, but if we had to call a special meeting, that would of course be included in the meeting definition. This is a little exception. It doesn't really apply to you, but the definition of a meeting does not include an on-site inspection of a project or program. It's not really applicable to this board, but for informational purposes, you could have a public body that appoints inspectors to perform inspections and delegate certain decision-making authority to those inspectors. So the question that arose, and this was actually an Attorney General opinion, but the question that arose is that a group of inspectors that goes out to inspect, I think in the scenario it was inspectors that were appointed to inspect the jail. But just because they're inspecting as a group and, almost acting as a fact finder, that's not included as a meeting. Now, if they were to make decisions as a group during those inspections, that would be included. But basically the exception here is that on-site inspections just for fact finding purposes do not qualify as a meeting. So a meeting does not include a chance meeting between two or more members. The biggest thing here is that you have a chance, you can have a chance meeting with another member. If that happens, you just need to make sure that you do not discuss board business. If you did discuss board business, then that chance meeting turns into a meeting under the Open Meetings Act. And it's inevitable that some of you may be, friends or colleagues in the industry. You may run into each other. There's nothing wrong with that. Just remember, if that happens, just don't discuss any board business. If you did discuss board business, it would technically be a deliberation of some sort, and so it would qualify as a meeting. So this is a great example here of what's not a meeting, kind of what I was hinting on. If you two of you share a meal together, if you go golfing together, totally fine. It would not be considered a meeting as long as you do not conduct any board business if you're on the course or if you're eating dinner together.
Or dancing.
What's that?
Or dancing.
Or dancing, yeah, it's just like that. This is another example, and this happens all the time, but we have lunch breaks. We sometimes take breaks during meetings, adjournments, like we may have a multi-day meeting coming up. Of course, you're going to be around each other during that time. Again, the most important thing is just when you're, on those breaks, just don't discuss board business with each other if you're meeting with two of you. So for our purposes today, what we take from this is that both regular meetings and, again, like I mentioned, special meetings are also covered by the Open Meetings Act. So-called emergency meetings are also covered under the Special Meetings Act. Again, I don't believe you've all had a special meeting called in a while, but if that does happen, remember that is also open to the public and included in the Open Meetings Act. There's another exception to discuss briefly, and that's what's called an executive session. Executive sessions do not fall under the Open Meetings Act. You can go to the next slide, Kathy. So what is an executive session? If you ever have to meet with me regarding a lawsuit or a threat of a lawsuit against the board, you all can ask me questions during that executive session, and that would not be covered under the Open Meetings Act. So that's an exception to the Open Meetings Act. And then just last thing on executive sessions, if that does occur, just remember we can't deliberate about a matter before, before the board, or a matter that may be potentially before you. But it's a time where you can ask me questions if, again, there's a lawsuit or a threat of a lawsuit. That's usually when that happens. So how far does it go? This would be an example of something that's not an executive session right here. So an oral interview is conducted, this is, I think, from a specific instance, but an oral interview is conducted by the Civil Service Commission of Murray County with persons applying for jobs within the classified service of the Murray County Sheriff's Department. That would come within the Open Meetings Act. That's a matter before the board. Even though they may have been discussing it with their counsel, it's a matter before the board, and they're deliberating and making a decision on it. So that would not be considered an executive session. So now we're going to cover electronic communications in conjunction with the Open Meetings Act. So this example right here shows you what is okay and what is not okay. So if a board member emails the chair and says, here's a new news article, I'd like something included on the next agenda, totally fine. But what you can't do is, for instance, email the chair and say, here's a news item that came out about one of our licensees, we should consider revocation. At that point, it's deliberation. So that would be two members deliberating about a specific item, so that would be considered a meeting. But there's nothing wrong with you seeing something, and if you want to tell the chair, I'd like this put on the next agenda for discussion and deliberation at the next meeting. So you recall we discussed that chance meetings are okay as long as board business is not discussed. If you email another member or pick up the phone to call another member, that is not considered a chance meeting. You're making a deliberate action to do that. So that should be generally avoided. I want to emphasize that we're not saying that you can't communicate with each other regarding things unrelated to board business. We understand that may happen. Just cautioning you when doing so, and we would always advise to, again, just don't discuss board business if that happens. But the main point here is that if you do deliberately call another member or email, that's not a chance meeting. But if that does happen, try to avoid that. But if it does happen, it's okay. Just do not discuss any board business during that time. Go ahead, Kathy. Okay, this slide right here covers electronic participation by board members during meetings. Things to keep in mind: if we have a board member participating electronically during a meeting, all votes must be taken by roll call, and the members participating electronically must be identifiable throughout that meeting. So that may pop up, as you recall last year, we had that change in law where we're allowed to have board members participate electronically, and they're physically present for purposes of voting. But if that does happen, and I'll be jumping in there if I see that a roll call vote is not about to take place. But just remember, we always have to take roll call votes if we do have an electronic meeting where board members are participating electronically. And this slide right here covers more things related to electronic attendance by board members. Again, like I mentioned, if you are participating electronically during a meeting, you are considered physically present for the purposes of voting. Another thing to keep in mind is if we do have board members participating electronically and say we don't have a quorum, a physical quorum present, the statute states that the board must at least meet once a year with a physical quorum. I don't think that's going to be an issue with this board. Usually we have a physical quorum present, but if it does happen, we just have to remember that we have to meet at least once a calendar year with a physical quorum present. This slide right here covers some case law about how the Public Meetings Act should be construed broadly. Again, I'll just emphasize, if you're unsure whether something will be considered a meeting, just always remember to err on the side of caution. So what is required? We're going to get into the next little phase here, talking about what is required under the Open Meeting Act, and that really has to do just with the notice requirements. So we must give adequate public notice, and there's a three-prong test for that. The notice must be reasonable, sufficient, and posted. Go to the next slide, Kathy. So the contents of the notice must reasonably describe the purpose of the meeting or the proposed action to be taken. Go ahead, Kathy. The notice must be posted at a time sufficiently in advance of the actual meeting, and the notice must be posted in a location where a member of the community could become aware of such notice. You can go to the next slide. And then, yeah, there you go. The posting of the notice is contingent on whether the location would be one where members of the community could become aware of the notice. Our usual practice is to post that notice of the meeting and the agenda on our website, and that is completely sufficient. And that's what we've been doing for a long time regarding that notice. Go ahead, Kathy. So on this topic, what the Tennessee Court of Appeals has said is that the three parts, the contents of the notice, the timing of the notice, and the location of the notice, they're all equally important. But I'll just emphasize to wrap this up, as you're probably aware, our executive director, Chris, he takes care of all this notice phase, so it's not something you have to worry about. But I think it's good for you to know the requirements in that three-prong test there. So now we'll get into just what happens if the Open Meetings Act is violated. It's called nullity, and that's just exactly what it sounds like. If you make a decision or take an action that violates the sunshine laws, it's basically as that decision never happened. And that flows down, for example, to licensees. So to wrap up the Open Meetings Act, here's some summary points that we've covered today regarding the Sunshine Law and Open Meetings Act. The Open Meetings Act is designed to make sure all board business is conducted in a way accessible to the public. It applies to you both as an individual member and collectively as a board. Here's some more points. In a nutshell, all gatherings of more than one member are meetings and are covered by the Open Meetings Act, including regular, special, and emergency meetings, and including committee and subcommittee meetings. The only exception, as we discussed, is the executive session, which is your opportunity to ask your board attorney, me, questions, but you can't deliberate or decide on anything during those executive sessions. For every meeting, you must be given, every meeting there must be adequate public notice, and that's what we just talked about, the content, the location, and the time. If you violate the law, any of the Sunshine Law, any violation of violative acts are void. Your decisions are like they never happened, and cost of litigation and attorney fees may be assessed against the board. Okay, this is the last topic here. You all probably remember this case, maybe when you were onboarded and in other refreshers, but it's the NC Dental case versus FTC, which made it all the way to the Supreme Court. So a little background here. The NC Dental Board issued 47 cease and desist letters to non-dentists about their teeth whitening services. The FTC, Federal Trade Commission, filed a complaint arguing the board violated antitrust laws by unilaterally ordering non-dentists to stop providing these services. In response to the lawsuit, the board argued state action immunity, that they were immune from liability under the action that they took. The case went all the way to the Supreme Court. The court rejected the board's state action immunity defense because it said the board did not receive active supervision by the state when it interpreted that act as addressing teeth whitening and when it enforced the policy issuing cease and desist letters to non-dentist teeth whiteners. The court said that the immunity for state agencies requires more than a mere facade of state involvement. Essentially, there was not enough state active supervision in this case for the board to defend on the ground of state immunity. This is what the court said about the active state supervision, that active supervision need not entail a day-to-day involvement in an agency's operations or micromanagement of its every decision. Rather, the question is whether the state's review mechanisms provide a realistic assurance that a non-sovereign actor's anti-competitive conduct promotes state policy rather than merely the party's individual interests. So that case was, I think, 4 or 5 years ago. So Tennessee responded with enacting some legislation to make sure you all are covered, essentially. So in 2021, the state established supervising officials. So who is your supervising official? That would be the commissioner of the department or his designee. So for our case, that's probably going to be Reed Witcher, who's the assistant commissioner over regulatory boards. So by statute, his role as the supervising official, or the statute states, each supervising official shall ensure that the actions of regulatory boards that displace competition are consistent with a clearly articulated state policy. So here, let's see, go ahead to the next slide, Kathy. This kind of gives you a role of the process in statute about the supervising official. The supervising official shall evaluate whether the action that you take may constitute a potentially unreasonable restraint of trade that requires further review. If the action does require further review, there's a process implemented. So all this said, the NC Dental case was a landmark case for regulatory boards across the country. But since then, Tennessee, and including many other states, have enacted laws to ensure that there is state action, active supervision. So if this were to happen, we've got that state active supervision in place, and, you know, the board would be able to claim state action immunity. So it's just it's a good case to review and just to keep in mind about how that went wrong. And the legislator and the state of Tennessee has put into place mechanisms for that essentially not to happen within our boards here. And that's it. So if you all have any questions about this slide, the Open Meetings Act, public records, the case, feel free to reach out to me. And you can always reach out to me at any time over any questions that may arise with meetings or meeting with other members.
Okay, thank you, Kyle. Any further discussion, questions for Kyle or Chris on this? Do I have a motion to accept the board updates?
So moved.
Second.
Motion made, seconded. Any further discussion? All in favor say aye.
Aye.
Okay, public comment? Anything regarding public comment?
We've got nobody else online either, so. thank you.
Okay, all right. So do I have a motion to adjourn the meeting?
Make a motion, we adjourn.
Second.
All in favor say aye.
Aye.
Meeting is adjourned. Thank you.